We are back on. All the defendants are present, represented by counsel. Is the state ready to proceed with its next witness?
The state was ready up until about 20 seconds ago, where Mr. Hope brought something to my attention right now. Fine, you may have a moment.
You know, while they're discussing something, could I just make the record complete on an issue that involving Olivier? The objection I had to Ms. Olivier standing up and saying another witness will testify to the angle comment essentially was made. I objected on the basis that trial counsel was testifying. The court has not sustained that yet in front of the jury. I'd like to get the court to sustain that objection and cure it. That would be my request of the court.
Restate to the jury that statements made by counsel is not evidence, and go ahead and do that.
It'd be great if you said there was, you know, something like there was an objection, I sustained the objection. We can have a record of it, unless you, and then make that curative would be great. Thank you.
So, Judge, it was the state's understanding that that was a part of the stipulation between the state and Mr. Goff, is that it was not mentioned to then Officer Minshew, but that it was mentioned to another investigator or detective in the case.
I thought the stipulation was it. This witness never used that word.
So therein lies the problem with stipulations, ladies and gentlemen. I will remind the panel that any that questions made or statements by counsel are not evidence in the case, and they should not be considered as such as they had been previously instructed. And I go back to my statement about stipulations. If you're going to stipulate, I would suggest we not do that as a negotiation on the record with the jury present and then blurt out what a stipulation is until all the parties know what the stipulation is. My preference is that they be reduced to writing so there's absolutely no question what the stipulation is, and we can proceed from there. So I repeated what I said before the break. I will remind the panel of the court's preliminary instruction on statements and questions by counsel. All right. Is the state ready to proceed with this next witness?
Yes, Judge, just for clarification purposes, Mr. Hope just brought to my attention that one of the statements that Officer Brandon Berry will be testifying to is that a bystander came up and asked Greg McMichael, did he have a gun? And Greg McMichael said, no, I don't think so, I didn't see one. Greg McMichael then finishes that sentence with, but he attacked my son. The state's problem is, but he attacked my son has absolutely nothing to do with the knowledge of did he have a gun or not. And I think we're going to maybe get into a rule of completeness issue, so I just wanted to bring it to the court's attention that they're going to claim rule of completeness, and I'm going to say that has absolutely nothing to do with whether Greg McMichael said Mr. Arbery had a gun or not.
Okay, well, it sounds like we need to resolve the issue.
Right, and so I guess at this time, you're asking to be in and I'm asking that it be held out, and I guess we need a ruling.
Let's hear the basis for each.
I didn't hear you.
Let's hear the basis for each.
Okay.
And the basis for the state is that it is not a rule of completeness. It's not necessary to explain Greg McMichael's statement to this bystander who simply asked, did he have a gun? And the answer was, no, I don't. I'm paraphrasing here. No, I don't think so. I don't believe he did. But he attacked my son. But he attacked my son has absolutely nothing to do with the answer of did the victim have a gun or not. And that's the basis for it not being part of the rule of completeness. It's not necessary to explain that particular statement. It's not part of the context.
It misleads the jury if left hanging like that in this way, Your Honor. At several places, Mr. Greg McMichael says that he suspected or believed, or even talking later in the day to Officer Marcy, that he had a gut feeling, which Marcy used the word hunch, that Mr. Arbery may have been armed that day. Then we know after Mr. Arbery was shot, fell to the pavement, Mr. McMichael, Greg McMichael, pulled his arm out from under his body to see if he had a weapon in it. And at that point saw that he was not holding a weapon. So that's the full context of it. that he wasn't sure if he was armed or not, but after he pulled his hand out, he knew he was not, or at least he believed he was not holding a firearm, because that's how he got blood. Greg McMichael, got blood on himself is because he pulled Mr. Arbery's arm out to see if he was holding a firearm. And the 24-1106 says, when a writing or recorded statement or part thereof is introduced by a party, an adverse party may require the introduction at that time of any other part or any other writing or recorded statement, which in fairness should be considered contemporaneously with the writing or recorded statement. And then over at 24-8-822, that rule says when an admission is given in evidence by one party, it shall be the right of the other party to have the whole admission and all the conversation connected therewith admitted into evidence. The part at issue is when Brandeberry is talking to Greg McMichael, some other unknown, I think non-law enforcement person, bystander, has come up and can be heard on Brandeberry's body cam talking to Greg McMichael. At that point, I think Brandeberry is actually talking to Christy Rozier, who's either the coroner or an assistant coroner. And so the male speaker is talking to Greg McMichael. And the male speaker says, so the guy have a gun? And Greg McMichael says to this male speaker, not the officer, no, I don't know. I mean, I couldn't tell if it's one on him or not, but he attacked my son. And then there's overlapping conversation because Brandeberry, the officer, is speaking to Christy Rozier from the coroner's office. And Christy Rozier is saying her name, hey, Christy, coroner's office, talking to Brandeberry. And then the transcript has the male speaker still talking to Greg McMichael. Oh, really? That's in response to he attacked my son. And then Greg McMichael says, yeah, he came at him. The next line is Brandeberry speaking to Christy Rozier from the coroner's office. Yes, ma'am. And then Mr. McMichael still speaking to the male speaker. He tried to get the damn shotgun away. So either all of that comes in or none of it should, because he's not even speaking to a police officer at this point. He's speaking to some other person being recorded by the police officer's body cam. So therein lies the dispute. The state simply wants to have the male speaker asking Mr. Greg McMichael, so the guy have a gun. They want this in through the officer. And then Greg McMichael's saying, only no, I don't know. Even though there's the rest of this conversation between Greg McMichael and unknown male speaker, not the officer. So our position is either none of it comes in or all of that comes in that I just read.
Final word from the state as the proponent.
Explaining to this other unknown male person that, oh, he attacked my son, he tried to get the shotgun away, has absolutely nothing to do with his knowledge with the original question, which is, did he have a gun on him? I don't know. They're not related at all and are not necessary to put it into context, especially the statement that Greg McMichael did not know that did not know whether Mr. Arbery had a handgun on him or not.
Just looking at the roll.
Your Honor, just to say in further context here,
I'm going to object. I'm sorry, Your Honor. At this point, the state is going to start objecting when they want the last bite at the apple every single time.
Yeah, I heard the arguments, counsel.
All right.
Move in, response, and then move in, so reply.
response, but there is one other one that's related to it. When you're ready, I'll bring up.
So we're using the rule of completeness. It's a declaration made by one of the defendants. I guess it can be described as a self-serving declaration. Under the rule of completeness, the court's going to exclude it, having heard the arguments of counsel as presented here.
I have pages, I cannot
Can't hear you, Judge.
Okay, it's on. Under the rule of completeness, the court is not going to permit it. It being as the court understands then, what the state's argument is, and I didn't hear this, but this is what I heard from the argument, that it's a self-serving declaration that's made as part of that statement. All right. Specifically under the rule of completeness, the court is not going to permit that statement under those circumstances. So I'll permit the first part of the statement. That's not saying that that statement is just completely excluded. If there's a different way of doing it, so be it. But based on the arguments presented.
Could I add to that for your consideration one other place in the transcript where we don't have an agreement here, but it's related to, it's the same topic. It's 6 pages earlier in the transcript. The state has indicated the part they plan to introduce through the officer is Mr. Greg McMichael describing what he was doing after he saw Mr. Arbery run past him while he was at his house. And they have highlighted the part, I haul ass into my bedroom to get my .357 Magnum, and then they skip the lines and have the next thing he says, I don't take any chances. And what they skipped over, and we didn't reach an agreement pre-trial, was this, at the transcript, page 21, line 22. He says, these are the words Greg McMichael says, because we don't know if this guy's armed, because the other night, the guy stuck his hands down his pants. Now, for Bruton purposes, as we've done in other places in this very transcript, we would change we to I, so he doesn't implicate anything regarding Travis McMichael's knowledge. I mean, we'd be fine with we, but obviously for Bruton purposes, that was a concern for the state. So if it was to read, again, as the state has suggested we do in other places, changing we to I.
Do you have that page? I can just look at it.
Yes.
I'm listening to you, but it's hard to follow. It'd be easier to see it on the
It
page.
is
so-
kind of true. Oh, you have it, I'm sorry.
I don't.
Oh,
So you got-
I thought that the state provided all of this to the court.
If I had everything the parties provided to me in this case, you would not be able
I
to see.
thought you were looking at. I would not what?
You would not be able to see me.
Taller than the witness.
Your Honor, to expedite this, the state will take out the line, I don't take any chances.
Well, that's not the line that concerns me as much as the one before it, and in connection with the one we just had a ruling on.
Get me back there, because it looks like this was,
So if you go to
Closed.
page 21,
it was closed, so I thought it was open. I don't know which page it
I'm
was,
sorry,
21.
page 21?
yeah, page 21, beginning at line 17, and I'll just wait till you got a chance to read that paragraph.
So I'm looking at highlights here. What are these highlights?
Yellow is, and I'm gonna, if I can tag out, this all occurred while I was in the middle of my death penalty trial between my co-counsel and Ms. Dunikoski. And so if she could explain the color coding, that would help.
That would be helpful.
The yellow was the indication we received from the state as to what they intended to introduce out of these statements. The red was our indication back to the state as to what we believed should come in under the rule of completeness. The comment boxes to the right indicate whether the state agreed or disagreed. Am I saying that correctly?
No, the red was,
There's no red.
right, and on this
It's
page,
pink.
there is no red, there's other red within the
Pink.
transcript.
All right, pink.
And the blue, so what you've handed the judge is yellow and blue, I believe.
Correct.
So the blue was what the defense counsel wanted in as rule of completeness, the yellow was what the state was tendering in. So when, Your Honor, you look at, because we don't know if this guy's armed, because the other night the guy stuck his hands in down his pants, is what defense counsel wishes to put in to this segment based on rule of completeness.
That's correct. I had to change the ones we printed, Your Honor. The blue was very difficult to read through. So I agree with Ms.
In
Dunikoski.
fact, are you able to read the blue? Your
I
Honor?
am. It's a light blue on my transcript.
Okay. We changed ours to pink.
Yeah, I'm not going to permit, there's a couple of things going on. It looks like it's two separate thoughts, but then we start getting into Travis grabs, this is Greg McMichael talking about what Travis is doing. Separate co-defendants.
We didn't highlight the Travis grabs his shotgun part. We did not highlight that. We weren't asking for him to read that.
The issue though is that it implies, but the full statement is Travis grabs his shotgun because we don't know if this guy's armed. You want to change the statement simply to, I don't know if this guy's armed because the other night. The context is lost because he's talking about Travis and the shotgun and why the firearm was grabbed. He's assuming that Travis's thoughts are because Travis had seen the couple nights prior. This is the way I'm reading it, or it can be read. A couple nights prior that he stuck his hands into his pocket, I think it was, or down his pants. And there's that interaction where Travis thinks he may have had a gun a few nights earlier. That's what this is talking about, as opposed to what Greg McMichael was doing at the time. So that's the issue I have, and I can see where, I can understand where the Bruton issue comes up with that.
Your Honor, just to further clarify though, he's explaining why both he and Travis grabbed firearms. And so this actually completes the answer to why did you get your .357 Magnum? And then he adds in that the reason I got my gun is the same reason Travis got his shotgun. So it does apply to him as well.
Yeah, no, the court's not going to let it, because there's other parts of this that also, in order to give it additional context, we start getting into Bruton, because there's other, right in the middle of this, so and I'll use the language in the transcript, not my language, I haul ass back to the house, back in the house, and I said, Travis, this guy's running down the street, let's go, let's go, let's go, that's quote. So, I haul into my bedroom to get my .357. Talks about it being Glenn County PD issue.
Your Honor, it kind of leaves it hanging out there without context, as if he went to get his gun to fulfill this chasing and executing.
I'm working through, I'm trying to figure out how in this transcript you can start parsing that down.
You just did it, Your Honor, with the other witness. And that's the whole point of the reading it out, Judge.
Okay. The way I see it, to solve, not solve, but to alleviate any Bruton issues, it would be to add in language, because I don't know if this guy's armed.
That was our suggestion, and I believe the state.
Well, you went into, because the other night the guy stuck his hands in, that would be, that then is mixing the two together, at least to me reading the transcript.
Maybe it's the copy I gave you that's not ours, Your Honor, but, and I apologize, there's so many floating around. I really thought you had the set, but that is what we were asking for, what you just described.
Yeah, I just said, but no, what I heard was the continuation of that is, because the other night the guy stuck his hands in down his pants. That's what Travis McMichael saw.
That's the explanation for why Greg McMichael got his gun. So it's not offered for the truth of anything, it's not hearsay. It's to explain, it's to put in context and answer the question, why did you run back into your bedroom, Mr. Greg McMichael, and grab your .357 Magnum? Let's say that's a question.
Because I don't know if this guy was armed.
Well, no, because he thinks that he may be armed, because the other night, his son saw him make the spurted movement.
I understand that, but yeah, no, the court will permit for completeness the explanations, because I don't know if this guy's armed. Beyond that, to me, the court, you'd have to take additional steps to make the assumptions that are being implied.
I'm trying to figure out how that puts the, how it actually does put it into its proper context. Because if the question is, why did you get your gun, Mr. McMichael? And the answer that's now being allowed is, because I don't know if this guy's armed, it doesn't make any sense. Why would you grab your gun if you don't know that he's armed?
I'm assuming it will make sense with the evidence, because what I heard in opening statements is that the defense or somebody's going to get into Travis McMichael a couple nights before and what happened at the outhouse, or the porta potty, or whatever you want to call the red structure.
And that will happen, I do suspect, but I'm arguing right now about just what this next witness is going to leave the jury with, and it's not going to be accurate. It's going to be misleading. The reason it's going to be misleading is because we're not giving it its proper, complete context.
Okay. That's on the record. I appreciate the argument. Again, the court's ruled. We'll go ahead and add that in for completeness, but the rest of it, the court has already stated on the record its concerns about
So
the
part
balance.
that's okay, just so I don't step, unless the state's going to do it, is now cause I don't know if this guy's armed. That part's okay. All right.
Whose transcript do I have? All right.
There may be one more. Oh. Yeah, the other one I'm concerned about that we mentioned, I just wanted to highlight, make sure the court followed me on this, is that the page 27. Oh, here it is. Sorry. This is the one you didn't have the benefit of the transcript for a moment ago, and it might be helpful. It's at the very bottom of page 27. And actually, the male speaker appears all the way over. He comes up around page 26, around line 15. And from 26, line 15 on, Greg McMichael is actually talking to a bystander while Brandenberry is talking to other people. But he's close enough to Greg McMichael that he's picking him up on his body cam.
Nobody has any idea who this is?
I'm sorry?
Nobody has any idea who this person is?
I don't.
You can't, nobody even picked it up from the body cam?
It's not Brandenberry.
It's not Brandenberry. I don't know. It's if you're watching the body cam, you see a civilian walking up to the crime tape or near it, talking to Greg McMichael, but I don't know who it is. We haven't, I don't think we've got him in the case anywhere. Oh, you want me to keep going? So, as you can see, if you go page 26, I thought you were reading, I'm sorry. Middle of page 26, male speaker is up there talking to Greg McMichael. And at this point, Brandenberry's not interviewing him anymore, he's not speaking to him. And so when you get to the bottom of page 27, you should have a yellow highlight there at line 25, which indicates this is what the state wants to have Brandenberry read. And I suppose they want him to read male speaker. And so the jury's going to hear him read male speaker. And up above that, there's a section, and on mine it's pink, I'm guessing on yours it's light blue. The state wants to put in a section, and I think we did try to expand this to give further context, but it's the same problem. It's Greg McMichael talking to some other person who's not law enforcement. So, and he's not a witness in the case. So our position would be from 26, line 19, which the state and I had an email exchange over the weekend about expanding the context all the way through page 28, line, wherever Brandenberry begins talking. Actually, it's going to be all of that. The next one is line, page 31, line 4. That's where Christy Rozier is talking to Greg McMichael, and she's possibly is a witness in the case, and she's the coroner. So anything from page 26, line 19, through all the way up to the page 31, line 4, where the state's going to pick it up next, should be out because it's not a law enforcement officer talking to him. I don't have that witness. Yeah, it's not the witness who's going to be here testifying. These wouldn't be the witness's words to Greg McMichael. It'd be some other unknown person.
If I may, Your Honor, this is just like a jail phone call. It's the statement of Greg McMichael. He's talking to some unknown person. So what if we don't know who the unknown person is? It is the statement of Greg McMichael being questioned by a male speaker. It's caught on body cam. Brandenberry is standing right there. He's watched his body cam video. He's checked it against this particular transcript. And with regard specifically to, I guess, the first thing the defense attorneys for Greg McMichael are asking for is for all this to be out, which the state disagrees with. The second thing is that I did agree that on page 26, I would go ahead and put in context that the male speaker says, I was concerned that it might have been that drunk guy that lives up here on the corner in that house on the far right-hand side. He's always walking in the road. Greg says, that one that kind of shuffles? Yeah. And Greg says, yeah, no, this ain't no shuffler. This guy's an asshole. I mean, he was hooked up when he came around the street. And then I agreed to, was he walking? And then Greg McMichael says, no, running flat out. I don't know where he was coming from down there. So these are the statements of Greg McMichael. They come in, and the state agreed to begin on line 22 on page 26 to continue this on to actually give it context over and above just starting off with, this guy's an asshole. I mean, he was hooked up when he came around that street. So that's what the state's looking to put before the jury in context. And defense contacted me over the weekend, said, can we put it in context? I said, sure, we'll add the shuffler part in without a problem. So the state's going to agree to that, to put that in context. But these are the statements of Greg McMichael. It doesn't matter that we don't know who he's speaking to. It's captured on body cam, overheard by Officer Brandenberry, who's reviewed it for accuracy, and it comes in.
Onward.
Yes, Senator. For the rule of completeness, just to emphasize what it should be doing, the concern is it's not that it lets in otherwise inadmissible evidence. It does do that, but that's the very purpose for the rule. And I think when the court said earlier that it was self-serving and therefore it's inadmissible, the rule of completeness, the very idea of it is evidence I could not introduce through a witness initially because it's self-serving. Say if Brandon Berry's up there and I wanted to get in a bunch of exculpatory stuff, I couldn't do that. Unless, under 822, it's to complete the context for the statement the state has picked out of the conversation and has introduced because it is inculpatory. And so saying, as they do, that Mr. McMichael says to the male speaker, when asked, do you have a gun? No, I don't know, is out of context. It's incomplete. Yes, it would be self-serving to say, I thought, if I was doing it initially, I thought the guy was armed because of what happened the other night. But when the state picks out, no, I don't believe he had a gun, and just leaves it hanging out there out of context, the rule of completeness comes in and says, okay, it might have been otherwise inadmissible, but now it's admissible. So that's our argument. It should come in just to give the proper meaning to the words picked out by the state to use against Greg McMichael.
To the extent that this spills over onto Travis McMichael, even though we're trying to be very careful about Bruton, we adopt the rule and the law that Greg McMichael's attorney is giving to the court, and would ask that the court allow a more complete statement to complete the rule.
I'm just going to read through this and see what it actually says. Let me just make sure I understand what I'm looking at too. So with these body cams, basically the reason that these have been all cut up the way they're cut up are the Bruton issues, correct?
No, sir. No, sir. That's not true. The reason they're cut up is because the state is cherry picking the parts of the statement it wants, allowing for the Bruton issue. So I've never seen defendant statements picked apart like they are, but it's like 1/10 of their statements are being put into evidence, and we're asking for the rest of the statements that finish the answers come in.
I think as far as the McMichaels go, I don't even see a Bruton problem here. But that was the concern the state had, and so we're trying to roll with it. And so that's why we're bringing up completeness, because, okay, if we're going to pick out little, as you can see, if you just look at the pages and you look for the highlighted parts, it's just little pieces here and there throughout a pretty lengthy body cam. And context is critical here. It's totally critical. And to pick out sentences like this and not give them a fuller context, which sometimes requires the whole conversation, but we can't do that. I get that.
I'm just going to take this in the back and sit down and take a look at it instead of having everyone sitting here waiting on me to read through it. I'm going to read through it, not the whole transcript, but the portions we're talking about. Come back, make a ruling on it.
I think just one other thing. The state actually said, hey, we're just going to play everything. And that includes Mr. Bryan's statements to Seacrest. And at that point in time, I got a no. That's a Bruton violation. We cannot waive Bruton, and we're refusing to waive Bruton. That's what I got from the defense attorneys. At which point in time, I filed a Bruton motion, and at that point in time, I asked them, what is it you don't want me to say? And at that time, they said, no, state, you need to tell us what it is you want. So this complaint now that I'm cherry picking their statements, they said, what is it you want in? And I said, this is what I want in. I sent these off to them. They marked them up. I sent back with my comments. This has been going on all of September, October. and we've now spent 45 minutes dealing with something that was supposed to be done a while ago.
I obviously read the motion. It came up in May, I think, at the motion hearing. I understood it'd be figured out amongst the parties. Sounds like it hasn't been. I'll say this, it kind of cuts both ways with this. I understand the Bruton issues. I understood that we were going to be addressing the Bruton problems in the transcripts. I'll be very candid, the way that the body cam narrative was presented through Minshew, with the way these things are cut up, makes things at times difficult to digest. That's why as I'm sitting here looking at it, I want to take a read through and make sure I understand exactly what the context is, because I'm not sure all of the context was appreciated. And I'll, again, be very candid about it. That's a double-edged sword for the parties. But the court does want the best evidence before the panel that we can get before the panel. So I'm going to take a look at the transcript and make sure I understand exactly what's going on here before we take it any further.
And Your Honor, we'll see it not only for Greg McMichael, but also for Travis McMichael. There's an extensive interview of Travis McMichael, not yet on the table. Same issue applies, and it's going to be more of the same thing that we're going to have to bring to the court's attention.
Well, this is just rule of completeness on the statements that the state is asking to present. So that's all I'm addressing right now with this witness. There are two. The one that I ruled on, I'm going to go back and think that through, make sure I understand exactly what the context is, and I'll come back with a ruling. Yes.
Your Honor, so far, I don't think Ms. Dunkowski and I have had any real issues. That could change, I suppose, but I think the lawyers are working really hard to work through these issues.
Well, I don't doubt that. But as was demonstrated by the stipulation, sometimes one person believes that they've agreed to one thing and another believes they've agreed to another. So that's the nature of the beast, which requires the court to take a recess. We just may keep everybody available over the next 10 minutes or so. Hey, Amanda. Amanda, do you have the site on West V State?
Yes, I didn't have this set up on West V State. I believe it's there. I don't remember if it was in.
Just, yeah.
Did we send it to you?
Yeah, send it to me. That's fine. Okay, we are. Let me get my mic on. Okay. We're back on. Defendant's present, represented by counsel. Took a look at this in the back. Here's what the court is going to allow. On the first issue, having come back and done a little bit of research on this, we've got West v. State, which the court based its prior ruling on the incriminatory self-serving nature of the statement. If I can get my brain right. Site, I've got West State, Georgia, 66. It's an old case, but effectively would permit even a self-serving statement to come in under these circumstances generally. So I am going to permit in the first issue, the haul back to the house. I haul into my bedroom to get my .357 Magnum. I am going to permit the defense then to get this statement in because again, we'll keep the Bruton issue there, don't know if this guy's armed because the other night the guy stuck his hands in down his pants. Again, the court ruling was based largely on the serving nature. I thought that really wasn't necessary to explain. Giving it context and having read through it, now I understand what the defense is trying to do, and I'll go ahead and permit that. As to this male speaker that comes out of nowhere, this mysterious male speaker that I assume somebody at some point did figure out. But what I'm going to permit is starting on page 26, starting at line 22, brings context to what the state wants to get in on line 27. The conversation always is also, I think, in full context down to the end of line 3 on page 28. So the court's going to permit then expanding what the parties have agreed to, what I understand is going on. I'm not touching the rest of the transcript, all the decisions that were made. This is simply based on what the court has read here from page 26, line 22, to page 28, line 3, in order to give context to the statement that the state intends to use. Does everybody have those page and lines?
We do, and I presume since the state's calling Brandenberry at the moment to instruct them to change we to I. Otherwise,
Let's go ahead and do that. Let's make sure you understand. Because I understand that is the Bruton issue that I don't want to have to go through the process of seeing if there's a waiver on that one sentence. Okay? Does the state understand the court's ruling?
Yes, Judge.
Okay. We go ahead and inform the witness then. Just changing the we to I on the page 25, I think it was.
Yes, Judge.
No, it's not 25. I'm sorry. Sorry, 21.
what was 21?
That's the changing we to I.
Oh, okay. Thanks.
Yes, I've instructed him, he knows that, but I will ask some indulgence on leading in order to make sure we do not violate that Bruton situation.
I'm sorry, I didn't catch that.
I'm going to ask some indulgence on leading in order to make sure we don't violate any Bruton situation.
Yeah, I don't know what you mean, but we'll see.
I think I understand the context of the question. The court, again, the state needs to take witnesses on direct, but this is the way this has been done, cutting up this transcript, I'm willing to give the state a little bit of leeway to get the witness to the points in the transcript that we need to get to that have been agreed to by the parties and which the court has now ruled upon. I think that's it. I'm not saying we get to lead the whole time, but in order to move this along and make it clear what we're doing. Okay. Okay. I understand we can now get to the witness. State ready to proceed?
Yes, Judge, the state is ready to proceed. However, we have two witnesses here, one who's a short witness, I believe. Of course, I say that, I know the danger I'm stepping into. And then we have Officer Brandenberry, who I now believe will be probably a little longer. Given it is 4:22, would the court prefer I put up Brandenberry, maybe going to 5:30, or would the court prefer that I put up Adam Jackson right now, who's much shorter?
So the state thinks the Brandenberry direct is going to be an hour?
I've got 7 pages of questions, so yes, I think it may be.
That answers the question. Now, let's do the short witness, and then it looks like we'll get to Brandenberry tomorrow.
Thank you, Judge.
Do we know who that short witness is?
Yes, Adam Jackson.
Okay, everybody ready to go on that?
So, with that note.
Let's give everybody a chance to adjust their notes. We're gonna need the panel though. Yeah, okay, yeah, because we need to introduce the witness. Is that? Oh, is Liddell calling him in? Is the state ready?
No,
yeah.
unfortunately, the state needs a moment to shift for a second. Someone in Adam Jackson's body came to
Don't blow it up.
Aye, aye, Captain, I will not.
Judge, while they're waiting, I have another one of those. Every time I get downstairs, I think.
February 29th.
Thank you, Judge, for that indulgence. We're now good.
Okay, stay ready to proceed?
Yes, Judge, we are. We're calling, I'll wait till the jury's in.
Okay.
Thank you.
All rise for the jury. Please be seated.
Welcome back. All right. Oh. Yeah, we'll just wait for the state to call the witness. All right, we're ready to proceed with the evidence from the state.
Thank you, Judge. At this time, the state will call Officer Adam Jackson.
Swear to tell the truth, whole truth, and nothing but the truth.
Yes, sir, I do.
Go ahead and have a seat.
All right, Officer Jackson, how are you?
I'm good.
Go ahead and state your full name and spell it for our court reporter.
My name is Adam Tyler Jackson, AdamTylerJackson.
All right, and how are you currently employed?
I am employed by the Glenn County Police Department in Brunswick, Georgia.
All right, and what are your current job duties and responsibilities with the Glenn County Police Department?
I'm a patrol officer, so my job duties include responding to service calls when people ask for a police officer, patrol, drive a marked patrol car.
And how long have you been with the Glenn County Police Department?
I started in March 19th, 2019.
Now, have you spent your entire career in law enforcement with Glenn County?
Yes, I have.
Right. And so, you've attended classes and training at the Georgia Peace Officers Standards and Training Council?
Yes, I have.
All right, so you're post-certified.
Yes, ma'am.
All right. And do you have to go through a police academy, or did you go through post?
Police Academy.
And have you always been in the patrol division with Glenn County?
Yes.
And what Baker are you in?
Currently?
Currently.
Baker 9.
All right. Back in February of 2020, what Baker were you in?
I believe it was in Baker 11 on the north end of the county.
Now, today you are dressed in a suit. When you are on patrol, how are you usually dressed?
In a standard police officer uniform, With at the time there was green slacks and a tan uniform shirt, badge on the shirt, name tag.
And normally, when you're driving patrol, are you driving a marked police car?
Yes, big white police car with big police letters on the side, lights on the top.
All right. And do you also wear a body cam as part of that?
Yes, I do.
So are you familiar with the Satilla Shores neighborhood here in Glenn County?
I am now.
You are now?
Yes, ma'am.
All right. And what county is Satilla Shores in?
In Glenn County.
Now, had you ever been called personally to any burglaries or entering autos within the Satilla Shores neighborhood in 2019 into January, February of 2020?
No.
So prior to February of 2020, did you know Mr. William Roddy Bryan?
No, ma'am.
And prior to February of 2020, did you know Travis McMichael?
No, ma'am.
Prior to 2020, did you know Greg McMichael?
No.
All right, so I'm going to draw your attention specifically to the afternoon, Sunday afternoon of February 23rd, 2020, around 1 in the afternoon. Where were you?
I was, again, patrolling the north end of the county towards Jessup, and Officer Minshew was responding to a suspicious call, and at some point on the radio he said, "Shots fired." So obviously myself and several other officers all start heading that direction. Want to assist him, make sure he's okay, figure out what's going on. So I started heading that direction, got to the Satilla Shores neighborhood. At the time, I was a fairly new officer, so I took on a role assisting other officers, more experienced officers, with handling things at the scene. My supervisor arrived shortly after that, and he asked me to go speak to any residents, see if anybody witnessed anything or anything like that. That was generally what I was doing.
All right, so how long do you think it took you to get to Satilla Shores from where you were at the north end?
Probably 12 minutes, 15 maybe.
All right, so when you got there, were the fire trucks and EMS already there?
I don't recall if they were there or not.
All right, so in preparation for your testimony today, did I meet with you previously?
Yes.
All right, and did I have you look at your body cam video?
I think at the time we hadn't looked at it.
Okay, but have you looked at it since then?
No.
No, you have not seen your body cam video?
No.
Okay. Did I ask you to look at your body cam video and review it?
I'm not sure if we discussed that or not.
All right, so when you arrived at the scene, who was already there?
Officer Minshew was already there, and I believe that Officer Brandon Berry, they either arrived the same time I did or just within a minute or two of me arriving there.
All right. And when you got there, you were in a patrol car.
Yes.
And what did you see as far as the scene itself?
I saw there was a body in the street, and I saw a truck over to the side of the road, and I saw Officer Minshew over where the truck was.
So what was the task that you were then assigned to do when you arrived on the scene at the corner of Holmes and Satilla Drive on February 23rd, 2020?
My supervisor, Sergeant Leska, he asked me to talk to people that lived in the area, see if there were any witnesses, see if anybody had cameras that maybe faced the street, anything like that. I talked to one gentleman named Diego Perez and asked him if he had any cameras on the exterior of his home. He said he did, and that he would see if he had any kind of camera footage. He returned to me a short time later with a thumb drive memory card, which he said had video footage on it.
All right, so let's go ahead and break that down. You're out at the scene and you're tasked with interviewing witnesses. Was this a witness you picked out or someone who you got directed to?
He approached the area. I talked to several residents, but he was the only one that had anything as far as having the video footage or anything like that. So he was the only one by name that I talked to and got his contact information and all of that.
And when you located him, who was he standing talking to?
I'm not aware of him talking to anybody else.
Okay. And he offered to provide you with a USB sort of jump drive,
Yes, he had a jump drive that he said had camera footage on it.
right? And at any point in time, did he ask you permission to go over and talk to Travis McMichael?
I don't recall if he did or not. If he did, I'm sure I would have said to stay where he was at, just, treating it as a scene. So.
All right. And with regard to the USB drive, did you actually collect that later from Mr. Diego Perez?
Yes, I did.
All right. Now, you didn't review the footage on that jump drive.
No, in a situation like that, I knew that we were going to have investigators respond, so I went ahead and just held on to that till I could give it to them.
All right. And once you obtained that USB jump drive, handed over to the investigators, what then did you do at the scene?
At the scene, I helped, we put up crime scene tape, got a crime scene log, which is just a sheet of paper where we write down everybody that's been on the other side of the crime scene tape. Got some other officers needed water, bug spray, things like that.
All right. And did you write a brief report in conjunction with the homicide of Ahmaud Arbery?
Yes, I did.
And your body cam video, did you upload that to the system at the Glenn County Police Department?
Yes.
Okay, so I want to make sure. You haven't looked at your body cam video?
I have not reviewed it. No.
All right. Will you be able to review it overnight if I ask you to?
Yes, I can.
Okay. All right. One moment, Your Honor. If you're able to watch about 1 minute of that body cam footage, would you be able to recognize it and authenticate it as your body cam footage?
Yes.
Okay. Judge, I guess I apologize. I'm going to ask the jury to step out so we can authenticate this body cam footage.
Your Honor, we'll stipulate to its authenticity.
So Mr. Goff has stipulated to its authenticity, and we have a stipulation?
So for Greg McMichael, we stipulate.
All right. At this time, the state will tender into evidence State's Exhibit 329.
Understand. No objection then from the defense.
No objection.
It's admitted.
All right. So I'm going to direct your attention to the screen right there. We're going to go ahead and look at about the first 55 seconds. All right?
Let me know what you need. That's me.
That's your voice?
Yes, ma'am.
You
That's me.
recognize it?
Yep.
All right.
You get a witness statement from that guy in the bulldozer to the left? Yep. Hello, sir. Hey, did you see any of what happened? No. You didn't see anything? You got video of it. You got video of it?
Probably have been running down here.
Okay, can I get your name? You got your ID or anything like that?
And I can throw it on a USB.
Yeah, that'd be great.
Yeah.
So who's the man that we're seeing right here that you're talking to?
That is Diego Perez.
That is Diego Perez. And who is he standing next to? Do you know?
I don't know who that is.
Okay. So I'm going to also go ahead and show you going to show you what's been marked as 317. And 317 and 318. Okay. So take a look at 317 and see if you're able to go ahead and recognize that.
Okay.
And is that a fair and accurate depiction of what is right there?
Yes.
All right, this time the state would tender the evidence states 317. And go ahead and tell the jury, oh,
No objection. No objection.
No objection.
good. Thank you. Go ahead and tell the jury what we're looking at there.
We're looking at a screenshot from my body camera footage of Mr. Perez standing near the scene.
All right. So just simply a screenshot of what we're seeing.
Yes.
And then when we look at State's Exhibit 318. Right. Take a look at 318. Are you able to recognize that as another screenshot from your body cam?
Yes, that looks like about where the video started when I first walked up.
All right. At this time, the state would tender to evidence. State's 318.
No objection. No objection.
No objection.
All right. So with regard to 318, you had kind of parked your patrol car down a ways, right? And had
Yes.
to walk up.
Yes.
And besides interviewing Diego Perez, you did not interview anyone else at the scene, right?
No.
Okay. How long did you stay at the scene after you turned off your body cam?
Not very long, since it was a busy day. Once my supervisor got there and we started getting other calls, he asked me to leave to go take care of some of the other business in the county.
Okay. That's after you had obtained the jump drive from Mr. Perez.
Yes.
All right. All right, so I got one last question for you. With regard to the body cam video, the dates and times, are you able to explain to the jury the dates and times and how the timestamp works on body cam video? In other words, this says 1825 on it, even though it has the date of February 23rd, 2020.
Okay. Yes.
Now, obviously, 1825 is not when this is taking place.
Objection. She's testifying now.
I
Hold on. Leading question.
Just rephrase.
All right. What time was it that you were there?
I don't set that clock that's on the camera, so I'm not sure why it's showing that date and time.
Okay, that's fine. I didn't know if you were able to explain to the jury why it shows that particular time. If you're not, it's okay.
I'm not, no.
Okay. I will go ahead and pass the witness.
Yes, sir. Afternoon, officer.
Good afternoon.
I'm Jason Sheffield. We haven't spoken yet about this case, have we?
No, sir.
Okay. Is it fair to say that you were there to lend a helping hand in whatever they wanted you to do? You had no specific role as you
Yes.
arrived.
Just to assist.
And you met with Diego Perez, who appeared to be eager to cooperate with you.
Yes, sir.
The taking of his license, that's just something that you do to try to document who the relevant witnesses might be.
It's just a little quicker than saying what's your name, what's your address, all that. It's all in one spot.
And it was your understanding that he had relevant information about what had been happening in the neighborhood, is that correct?
Yes, sir.
Specifically, what had been happening in the neighborhood as it related to the particular incident that was unfolding in the street there at that
Yes.
time. I interrupted you.
Yes, sir.
You spoke too soon.
Yeah, I'm just
Okay,
agreeing
yes.
with you. Yes, sir.
And so he went back to his home and he produced several videos for you on a thumb drive.
Yeah, he came back with a thumb drive and I didn't review it, so.
Okay, so you're not aware of the contents on
No,
the
sir,
thumb
I'm
drive.
not.
But it's, to your understanding, it is whatever the history is that's been going on in the neighborhood that may be relevant.
Yes, sir. It's a pretty standard practice businesses, people that have cameras in their homes, hey, do you have any video footage? And they'll, we just trust them that they're gonna collect the footage that they have access to and provide that to us. And in this situation, knowing that we were gonna have investigators respond, I had no reason to review it, so I didn't review that particular footage.
Fair enough, thank you.
Yes, sir.
No questions?
No questions.
Nothing further from the state.
Thank you, we step in.
Yes, sir, thank you.
And as I understand it, you are excused for the day, but subject to recall. Yes, sir. Thank you.
Thank you, Judge.
All right, ladies and gentlemen, we are at a good stopping point for the day. So we're going to go ahead and break for the evening. I'd like to have you ready to get started again at 9 o'clock tomorrow morning. During the recess, again, do not discuss this case amongst yourselves or with anybody else. Don't let anybody discuss this case around you or in your presence of hearing. Don't go looking for any information about the case. Whatever information may be out there, again, if you pick up the news, don't pick up the news, don't pick up news feeds, social media, whatever may be there. I'm just going to ask you to step away from all of that. And again, if anybody does approach you about the case, please notify the court, and we'll go ahead and see whether we need to address that. So, with those instructions and all of the other instructions I've given you to this point, we will see you tomorrow morning at 9 o'clock. Thank you for your service here in the Superior Court of Glenn County. Have a good evening.
All rise for the jury.
No, that's not the case, and that they have issues with rule of completeness. So, having been down this road before, what I assume is going to happen is we're going to have Investigator Nohilly testify to all of the things that we told them we were going to have him testify to, and then they're going to get up here and they're going to ring the bell and say, well, isn't it true he also said do, and then we're going to have to be in the position of objecting that that's not part of rule of completeness, but the bell's already rung and the jury's already heard it, because my belief had been that they would give me what they believed to be rule of completeness so we could iron those issues out beforehand, because that was the direction of the court. And that is not what has happened. So we're now in a position, the state's in a position of having to bring this to your attention, that there was no meeting of the minds on the Travis McMichael statement, and that basically we're going to object at this point in time to any desire for any rule of completeness statement, simply because we have been placed in a position, an untenable position, to have not been informed as to what it was that they wanted in, and that was the order of the court, and that was what I believed your ruling to be, that we were supposed to provide them with this and they were supposed to get it back to us, and now we're going to have this ringing of the bell and this cross-examination where the defense is going to get up here and they're going to read the statement, and no matter if we object, the bell has been rung. And we're asking for a ruling on that at this time. Thank you, Your Honor.
Yes, Your Honor. So we did exactly as the court asked us to do. We looked at the Bruton issue very squarely for an extended period of time, and went back and forth with the state on the Bruton issue and submitted to them in red ink and in highlights all the things that we needed to address about Bruton, and did so in good faith, and arrived then at what we thought the state was going to be offering under Bruton that would not violate our confrontation rights. We told the state, however, that as for rule of completeness, we would wait and see what exactly they put in at trial, and before we then asked questions to complete the information, we would identify what we thought needed to be heard to complete. We would share it, show it to the court, and the court could make a ruling. So the rule of completeness is a separate issue from Bruton. Our Bruton fears and concerns were about confrontation. And I think we've done an excellent job working through that issue with the state. The rule of completeness, though, Judge, is one of those things that kind of happens during trial at times, depending on what the state
wants to offer. It is not necessarily a pre-trial matter. It's something that can easily be brought to the court's attention and dealt with. If the court directs me to get into what we think would complete these statements, I'm happy to do so. It's very easy, but we did not undertake that with the state, and we made it clear to the state that we were not going to undertake that with them, that we were only working on Bruton. So for that reason, I think we're in compliance, and I don't think it's going to be too complicated for these issues to come up as they do. I will simply show the state, I will show the court can rule, and we can move on. I won't ring the bell in front of the jury.
Understanding we just spent 40 minutes dealing with only 2 of those issues.
Judge, the state has elected to present its case through the statements, through an indictment that indicts 3 people as conspirators. They chose to bring this case to court in this manner. Now they want to make their case a case that potentially violates these gentlemen's confrontation rights. And so in order to do that, they must tiptoe carefully through that. We have cooperated. We have tried to talk with them and share our thoughts with them, and have done so over several weeks and months to comply with that so that our clients' rights aren't violated as they try to make their case. But rule of completeness, as the court sees, is simply a way to complete the subject matter that the state has introduced. And so we don't think it's going to be that complicated. Now, if the court directs me, I'm happy to give you the entire statement by Officer Nohilly. I've broken it down into subject matter, page, and line. And when the state gets into a subject matter that we feel needs to be completed, I can bring it straight to the court's attention. But otherwise, I'm not sure what else the court would ask us to do. But I'm happy to do whatever the court wants us to do. But I don't think we violated any kind of pre-trial order or ruling.
Final word from the state.
No, that was not made clear to the state on any level whatsoever. It's Travis McMichael's statement, and neither Mr. Goff nor Mr. Greg McMichael objected to any of it. However, it was not made clear that, oh, we're going to go ahead and do this thing where we don't tell you what the rule of completeness is so that we can discuss it in advance. There's been absolutely no discussion. I've not been told one single time, by the way, Ms. Dunikoski, on page 37, we think this extra stuff should come in. The Hogues did us that courtesy, Mr. Goff did us that courtesy, but we have no idea what page and what line this is going to come in to, and it appears we're going to be spending a whole lot of time, I think, arguing over it, because once Nohilly gets off the stand, we're going to be in a position of, okay, so on this page he said this, and then we want this in, and we want this in, and I'd put it in if I agreed to it in advance.
Well, I'm glad we stopped before 5 o'clock, because the first thing I want to do, which is the same thing I ask counsel to do anytime we're under an issue like this, let's get together and see really if there is an issue the court needs to address. And if there is, I'll go ahead and address it in context, and until I get a clear understanding of what's being objected to, there's not a lot the court can do other than vent and indicate that I will be very frustrated if we have to spend the entire day tomorrow on Nohilly's statement and back and forth about the rule of completeness. This strikes me as something that probably could have, should have been addressed well in advance of now. And my hope is that we have an opportunity over the next little bit to take a look at his statement and figure out where, if anywhere, there really is a dispute. I haven't gone through the statement. Told counsel when the Bruton issue came up to go ahead and work through the Bruton issues, and if I heard that there was a problem, to let me know. Apparently this has now been, sort of a slice of this has been taken out. This is the first that I'm aware of it, as is indicated by my ruling today on the record, on the fly, with regard to the rule of completeness. So, doing a little bit of tipping at windmills here, but hopefully by the time it gets back to me tomorrow, Nohilly's statement will have been reviewed, and I'll know exactly what I need to rule upon, if anything. So, nothing to rule on now.
Thank you, Judge.
Okay. Anything further then before we recess from the state? From Travis McMichael.
Yes, sir.
From Greg McMichael.
No, Your Honor.
From Mr. Bryant. All right. We'll see everybody at 9 o'clock tomorrow morning. Thank you.